On Thursday, October 9th, Federal Energy Minister Tim Hodgson made an appearance before the Senate, and he made some comments about the controversial 1 million barrel a day pipeline that Alberta wants to see built to the west coast, northwest coast of BC. The fact that they were controversial isn't really the interesting thing, though, here, is I think the minister was wrong. I mean, like he misunderstood how the process of pipeline applications and approvals actually work. I'll read what he had to say. To build, you need support of the jurisdiction you build through, and you need the support of First Nations. The proponent, in this case, the province of Alberta, needs to attract that support if they want to build. That's something between the province of Alberta and the province of British Columbia. That's incorrect. That's not how it works. And the reason I know that is because in 2017, 2018, I did a lot of reporting on the Trans Mountain Expansion Pipeline to Burnaby. And many of these issues came up and they were ruled upon. And I'll get into that in just a little bit. So there's two issues that emerge out of Hodgson's comments. One, Alberta needs support, agreement from the government of BC. And secondly, Alberta needs the support and agreement from BC First Nations. So let's deal with number one first. The city of Burnaby harassed and hounded the Trans Mountain expansion and their proponent, Kinder Morgan, American pipeline company, at every turn. The city mayor, Derek Corrigan, was a vocal opponent of the project. I remember covering rallies in Burnaby that were huge. Thousands of people would come out. First Nations were opposed. There was a lot of opposition to this project. And one of the things that Burnaby did is very clever, is that they dragged their feet, basically dragged the puck on permit applications, because even though this is a federally regulated project, they still needed to get some provincial permits, and they needed to get some local permits. Simple things like cutting trees through the right of way, or where they were going to build extra tanks at the tank farm. And the city just dragged the puck and didn't get it done. And so the company went to the National Energy Board, which is the name of the regulator at the time. It's now Canadian Energy Regulator. And it complained. And so the NEB investigated and discovered that essentially the company was right. The city was dragging the puck. And so this came to a head, and the NEB issued a ruling. Now, this is an important point here. The NEB, under the NEB Act, it's federal legislation, the federal government delegates its authority to the NEB to implement, to exercise, right? So the NEB is the one that manages the application and the review process and public input and comes to a decision. And then finally the decision goes to cabinet. And the cabinet has 90 days, and it can approve or put conditions on, or it can reject the project. So this happened not just once, but a couple times. And in this particular case, the NEB, in its power as a superior court, it issued a ruling that upheld the federal exclusive jurisdiction over pipelines that cross provincial borders. And the principle invoked here is called paramountcy. So what that means is that when there's a conflict between provincial and federal legislation and laws, the federal government's jurisdiction takes precedent. It overrides the provincial government. Now, there's another principle involved called cooperative federalism, because, there's all kinds of conflicts. You only have to look at the Alberta example to know, or the recent one, to know how many there are. But the provinces are always accusing the federal government of overreach. And so these come up all the time. So the courts have said for quite a while, we want you two levels of government to cooperate. Yes, there may be strictly, there may, one government or the other government may be in the right, but in the best interest of the public, we want you to cooperate to get this done. So the opponents of the NEB said that the cooperative federalism, that principle should govern the project. And so if the city of Burnaby had a problem or the BC government had a problem, that then the federal governments, all the governments should get together and they should work out a solution. And the NEB said, no, that's not the case. In this case, because the other governments, in this case, the city of Burnaby, was trying to frustrate the federal government, and there was no chance of them working together. Then it applied the principle of paramountcy. And so that became a precedent. I mean, this wasn't really under dispute, but this is the most recent precedent affirming the federal government's exclusive jurisdiction. Now, then another one came up. In fact, I think there were a couple of more. There's a long list of these, of conflict over this project. But the BC NDP were elected in 2017, and they tried to frustrate the federal government by trying to regulate the movement and shipment of bitumen in a pipeline inside the BC borders. So, that was pretty transparent, and the NEB was having none of that. And so they issued another ruling, again invoking paramountcy, saying that the provincial law, the bill that had been introduced, was clearly meant to frustrate the federal purpose, and therefore it was in violation of the Constitution, and it was the federal government whose jurisdiction would be recognized. So, out of all of this, is what Trans Mountain expansion taught us is that if the federal government decides that it wants a pipeline built from Alberta to British Columbia, it has all the jurisdiction it needs. It doesn't need the cooperation of the government of BC. That is not required. The question is, actually, there's a couple of questions. One is, can the federal government at the beginning attach a condition like Alberta, you have to get BC on side, and if they're not going to be on side, we're not going to approve the application. Now, see, that gets touchy because the way this is supposed to work, it's not supposed to be politically motivated. The company, the proponent, is supposed to put in an application, and that kicks off a process, and then the NEB, now this CER, supervises the process, and it's independent, and the government doesn't get involved again until there's an approval, and then it reviews it, and like I said before, attaches conditions, rejects, or approves. So that's got a little fuzzy. Can the government put conditions on ahead of time, or not official conditions, but say publicly, you two have to get together and BC has to agree, or we're not going to declare it as a project of national interest? We haven't got a precedent for that. And there are a number of unanswered questions here. So I'll be going in the next month or so. I'm going to find constitutional experts and pose these questions and have the conversation and see what they think about that particular issue. So that then brings us to the BC First Nations, which in many ways is very similar. And the question became, under UNDRIP, United Nations Declaration of Indigenous Rights of Indigenous Peoples. That's what it is. And the BC government had recognized it, and the federal government, I can't remember if they did it officially, legally, but certainly were politically governed by it. And so the First Nations argued that they should have a veto. Like when they have to be consulted under Section 35 of the Constitution when there are major projects, any projects really, that take place on their traditional lands, they have to be consulted. And there are there are cases that outline how that consultation is supposed to take place so that it meets the standard, the judicial standard that's been set. And at the end of it, here's what Natural Resources Minister Amarjeet Sohi, who's now the Edmonton mayor, had to say about this. We also understand that there might be groups that will still oppose the project, Trans Mountain expansion. That's fine. That's their right to do so. But that does not mean that if we fulfill our constitutional obligation to consult, that those groups may have a veto to stop the project. He said very clearly, First Nations do not have a veto. Now, I suppose that maybe this government could interpret that a little differently and say that, in fact, First Nations do have a veto. But then that raises the question, which First Nations? I mean, there are like over 600 First Nations in all of Canada, and I forget 78 or 80 in British Columbia alone. And almost all of the territory is unceded. There were no treaties in BC. So, if you've got a pipeline route and 15 First Nations are along that route, and 7 say yes and 8 say no, is it the majority, the 8, whose voice you listen to, or is it the 7? What happens if you have an elected council, which is under federal legislation, or you have a hereditary council, which is not recognized by the federal government, and this is what's happening with the Wet'suwet'en and the Coastal GasLink pipeline, natural gas pipeline. The hereditary chiefs opposed, and the elected council supported. Whose voice do you listen to in that case? You see how this gets really complicated really quickly. And that means that essentially the federal government has to provide leadership and it has to be based on the rules and on the precedent and the process that they've put in place. So I would say my take on Minister Hodgson, he didn't understand his own legislation or his own process, because the way he worded it to the Senate is pretty categorical. No project without the approval of BC and the approval of First Nations, which would essentially kill the project. And that is not the stated intention of both the Prime Minister and Hodgson himself. He's talked about how the federal government would like to have an application for a project of national interest, a pipeline, and they would like to approve it. They think that that's a really good idea. So there's very conflicting views here, conflicting comments. How do we interpret what Carney's doing and where Hodgson sits on this? So here's a comment that Hodgson made in the Senate, and kind of where I think he believes the things are at now. He said that Ottawa would act as a constructive participant in conversations between Alberta and BC, but suggested that the pipeline proposal is still in its early stages. Sorry, that was some CBC reporting, but this is a quote. Alberta has some work to do. Until they bring their proposal in 2026, it's a hypothetical question. Well, if it's a hypothetical question, why are you commenting on it? And with these controversial comments that seem to contradict legal precedent, the Constitution, and your own process. So this is all very, very confusing, and I don't think we're going to have an answer until the Alberta government puts it in its application in about 6 months, and which it says it will be the proponent. We'll see how that works out. But we need to get this cleared up, because this is, it's not just the pipeline that's at stake here. I've argued for a long time now that the oil and gas industry has been way out front of this. They've been demanding a pipeline, demanding expansion of the oil sands. Canada has a reputation for not being able to build things. Whether that's right or not is beside the point, but it's been said many times. Hodgson and Carney have both said it, that that's our reputation. And so if they want private capital to build mines and ports and rail and all sorts of other things that they want under their response to Trump's strategy, they need private capital. And they need to send a message to private investors that Canada can build. So if they're kind of dicking around with this and sending conflicting messages and saying things that contradict the Constitution and the CER process, what message are they sending to private investors? And investors want certainty. Is it this way? Is it that way? Is there some caution here? What are we talking about? And all Hodgson did with his comments in the Senate is muddy the waters. The Prime Minister isn't doing much better with his comments, his meeting with Trump and talking about reviving the Keystone XL pipeline project. It's a gigantic quagmire. It really needs some clarification, in my opinion, and that it would help if Minister Hodgson would get his facts right, but it really needs the Prime Minister to straighten this out. Unfortunately, I'm not hopeful that's going to happen.